Good morning and welcome to The Real Truth. I'm Tommy Spina. Today's guest is Lee Levine. He is or probably a retired partner. Is that a better way to say it?
Yes, sir.
I apologize if I threw you into some liability by saying that. He's senior counsel, I'll call him, with Ballard Spahr. Is that how you say that?
Yes, sir.
A law firm located in Washington, D.C., specializing in media clients and First Amendment related issues. Welcome to our podcast, Lee.
Thanks for having me.
Just for starters, just tell us a little bit about yourself and how you got where you are. I've read a little bit, and you referred to me by other professionals in the field of law that you practice. I'm a criminal defense lawyer, so I don't get exposed to what you've been exposed to over the years. So just take a minute to just break down your historical development and how you ended up in this area.
Sure. I practiced law for, 50 years. Almost all of it was representing journalists and news organizations, largely in litigation and to some extent in counseling, with respect to First Amendment issues, things like defamation, lawsuits, access to governmental records and proceedings, protection of confidential sources, prior restraints on publication, that sort of thing. And I got into it because I was a journalist, student journalist in college. And at the end of that, where I also majored in political science with a focus on the Supreme Court, I had to make a decision about whether I wanted to be a lawyer who represented journalists or a journalist who wrote about courts. And at that point, I thought the safer career path was to be a lawyer, so I did that.
So I always tell people I sort of stumbled into criminal defense work. It wasn't something I expected to be. I'm one of those guys that didn't grow up wanting to be a lawyer. I was trying to stay out of Vietnam for starters, so consequently I was trying to stay in school, and I wandered into the world of law, and after a period of time it just sort of started coming to me, primarily people charged with criminal offenses. So that's how my expertise developed. And here, 48 years later, that's all I'm doing. So it sounds like you were in the world of journalism. So you were on the fringe. And as you got your law degree, that just sort of evolved naturally for you.
Yeah, I'm one of these disgusting people who always knew what he wanted to do. So once I decided to go to law school, I was able to kind of plot a course and have some good luck, and wound up being able to practice in this area pretty much from day one.
Well, as recent as this week, journalists are under attack by our current administration, which makes this conversation quite timely, with respect to revealing their sources. Can you address what's going on, and constitutionally speaking, if you think that will get anywhere? I'm inclined to think it won't, but with the current makeup of our Supreme Court, it's impossible to predict, of course.
Well, what's going on, as best as I can tell from the press reports, is that some unnamed news organization, unless it's been named more recently than a day or so ago, published something about the rescue operations for the pilot and other military officer who was on that plane that got shot down in Iran that the Trump administration did not like, and the president threatened, not more than threatened, said that they were going to open a investigation, and they were going to go to the news organization and tell them either tell us who your source was or go to jail, which is a pretty, direct threat. But as we know, the president doesn't always follow through on his threats. So we'll have to see. In terms of the law, contrary to popular belief, especially in the context of grand jury investigations and subpoenas issued by grand juries, which is what this would be theoretically, the press enjoys very little protection under the First Amendment. The Supreme Court has only addressed the issue of First Amendment protection for confidential sources once, and that was more than 50 years ago in a case called Brandsburg versus Hayes. And in that case, although the decision is a little muddy because there was it was 5-4 or 4-1-4 in terms of the vote breakdown, depending on how you characterize a concurring opinion by Justice Powell. But the end result was that 3 reporters before the court in that case were required to go before a grand jury and testify. Since then, the lower courts have recognized a First Amendment-based privilege that reporters have to protect their sources in other contexts, civil cases, in some areas of the country, criminal cases in the context of an actual criminal proceeding as opposed to a grand jury investigation. But the result in the Brandsburg case has pretty much held in the context of grand jury investigations. There have been periodic efforts over the years to address this legislatively and federal, what's called the SHIELD law at the federal level. All of those efforts have stalled out at one time or another, most recently at the end of the Biden administration when the House had passed a very strong SHIELD law. The Senate Judiciary Committee had reported the legislation out to be voted on the floor, and after the election, the Senate Democratic majority in its last few months decided to prioritize confirming judges over bringing other legislation to the floor, so that version of the SHIELD law died. So if there is a subpoena that actually gets issued to a news organization arising out of this, in the context of a grand jury investigation, it will be very, very interesting to see how the courts deal with it.
Well, you've got the extra layer of protection in a grand jury setting in that a grand jury is secret to begin with. So my thought process right now is that, well, if they're required to provide that information, they being press people, journalists, no one's going to know what they said. I guess in the context of a criminal investigation, if something could be characterized as exculpatory, the government would be required to turn it over to the defense side of the case at some point, and that might spill into disclosing the source outside of the grand jury setting. But you draw a distinction, I suppose, between testimony before a grand jury and just give up your source in a civil setting, for example, in a deposition or something along those lines.
Well, the courts have, that's for sure, although the Supreme Court's never spoken to the issue in any context outside the grand jury. But there are 2 problems with the notion that the grand jury is secret and therefore, except in the exculpatory evidence context that you mentioned, the source's identity would remain unknown to the public. The problems with that are, the source is likely most concerned about the information about its identity being disclosed to the government, because then they're going to be prosecuted for leaking. So it's cold comfort to the source. And in terms of one of the primary reasons for having a First Amendment-based privilege in the first place, that is that it will have a chilling effect on sources' willingness to provide newsworthy information of public concern to journalists for reporting on to the public, it doesn't do much good. And then second, there is a really significant fear among journalists that testifying about their sources behind the closed doors of a grand jury will have a really negative impact on their relationships with their sources, where the source will not know what the reporter disclosed or didn't disclose about them and their operations behind the grand jury's closed doors, and therefore will be reluctant to trust journalists and provide information to them. That was, in fact, the motivation of the lead reporter in the case that the Supreme Court decided 50 plus years ago, a reporter for the New York Times named Earl Caldwell, who was reporting about the Black Panther Party that was at its height then in across the country. And Earl was concerned that if he testified behind the closed doors of the grand jury, the Panthers would lose confidence, that he respected their confidences, and therefore would deprive him of further access and deprive the public of the reporting that he was doing about the Panthers, which happened to run contrary to the preferred narrative of the government at that point, which was that the Panthers were just a bunch of armed thugs, and Earl's reporting really shed a different light on what the Panthers were all about. If I could deliver a shameless plug.
Sure. You were involved in
I was not involved in that case, but I've written a book about it that is coming out in the fall, and it's called In Bad Faith, Earl Caldwell and the Fight for a Free Press. It's something I know a lot about.
Well, it calls to my mind, historically speaking, why do we have this protection to begin with? And going back to the Declaration of Independence, 10 years later, the Constitution, I'm presupposing that in the revolutionary days, when this country was in its formative years and coming out of England, the press must have been something that the king didn't like. And the reporting of the press about whatever the press was back in that time frame, I suppose they had real papers, certainly not digital. Like, we don't have much paper anymore. Very few jurisdictions. Or there are a few out there. But I miss those days. But historically, what was the impetus for making sure that that freedom existed?
Well, that's a really good question. And there has been, especially of late, a lot of scholarship by historians looking at that issue, precisely that issue, as an outgrowth of the Supreme Court's fascination over the last decade with what they call originalism. Like what were the framers thinking at the time that they they enacted the Constitution and adopted the Bill of Rights. And with respect to the press, it is pretty clear that in colonial times, up through the Revolution and through the enactment of the Constitution and the passage of the Bill of Rights, the press in fundamental ways wasn't all that different than it is today. Printers were few and far between. There usually was a major printer or two in, every major urban area. Those printers typically publish their own newspapers. The newspapers contained news of the day and opinion articles and the kinds of things you might expect to see in a newspaper today. And the printers had what they in those days called correspondence. The word correspondent that we now are used to hearing, with respect to television reporters especially, comes from correspondence, which is people writing letters. And printers would have a network of people who would, especially abroad or in other states or colonies, that would write to them with the news of what was going on in their communities or going on in England, and those would be printed in their newspapers. So it is not surprising, just focusing on the issue of confidential sources for a minute, it's not surprising that there was a lot of, or were a lot of examples in colonial times of the Crown attempting to unmask the anonymous sources of printers, both the correspondents that provided them with information and people who wrote opinion columns criticizing the Crown under pseudonyms. One of the things that was on the minds of the framers when they passed the First Amendment, or enacted the First Amendment, was the need to protect printers so that they could, in turn, protect their sources.
Well, obviously, it was in an effort to thwart criticism of those in power, I suppose. To some degree. They didn't want to be criticized.
There is a lot of First Amendment shorthand, especially as it refers to the press, talks about the First Amendment right to criticize government. That's a kind of a central tenet of the Supreme Court's landmark decision in New York Times versus Sullivan, which comes out of your fine state. I always bristle a little bit at the use of that word because although it is true, it mischaracterizes to a significant extent what the framers had in mind. It wasn't just writing an opinion article saying that we think the king stinks. It was also reporting facts and information that placed the colonial government in a bad light, or was something the colonial government didn't want the public to know. And so, stifling what we would now consider to be news reporting was as much on their minds as stifling criticism of government.
Well, certainly in this day and age, at least I feel that our leadership does not like to be criticized publicly, although he gets a good bit of criticism. And when I say he, I should probably use a more global he, because I know it's not just one person, but he does seem to be the leader of the band, or the front man, for lack of a better word. I know he's surrounded by other like-minded people that are his advisors who are subjected to criticism at times. But this most recent attempt to get at who disclosed that there was a second surviving pilot that had ejected from a plane I mean, why is that so critical? I mean, I don't get it. We ultimately got the man rescued, and I know that uh, there was some concern that Iran may get to him first, but the fact that he was rescued to me seems to be the priority, not who told who that he even existed. At least that's my way of thinking.
I agree with you, which is why I think, and this is, my opinion based on the facts as I understand them, is that this is a pretext. This is part of a deliberate campaign to harass and intimidate the news media and to expand their legal right to do so. They know that reporters are vulnerable to grand jury subpoenas, and they know that they can mess with reporters by taking advantage of that in the context of what they can reasonably characterize or arguably characterize as a leak of classified information. The next step, of course, which we haven't talked about, which journalists are very concerned about, is prosecuting a journalist for receiving the leaked information. Under the Espionage Act or some other national security related statute, and that's never happened in our history. But I wouldn't put it past this crowd to do that at some point.
Mm-hmm. Well, the concern for me is, what do I believe when I see or hear or read what I read from the press? And I really have made a genuine effort since January to not even bother to turn on the news or read the news, because I don't know where the truth is. It's out there somewhere. I know that, but as one of my guests in a prior season said, there are no guardrails, especially in the digital age. There was a time, New York Times versus Sullivan, for example, that's the leading case when it comes to defamation and whether you're a public figure. And I remember that from law school, but that's about all I remember. Where there was accountability beyond the reporter, i.e. the New York Times, with a deep pocket that could be gotten to for compensation if someone felt they had been defamed or libeled publicly by a reporting agency. In that time frame, it was the New York Times. Nowadays, I don't think that exists. Especially with the digital aspect of things. Is that a fair assessment?
The issue that you point to, which is at bottom, the alarming rise in the number of people in this country who get what they think is their news through social media or other online digital platforms that do not have the editorial processes or the internal checks or rigor of a truly professional news operation. It is true that a lot of those people are not deep-pocketed, and even if you know who they are, even if they're not, just circulating stuff online anonymously, it's not worth suing them because they don't have any money. And so the role of defamation law in acting is kind of a governor on the dissemination of falsehood goes away, and I think that is certainly true. And to that extent, the internet has been both a blessing and a curse for the cause of finding truth. On the other hand, I think things remain the same, at least for the moment, with respect to real journalism, both in terms of the value that it adds to the body politic and the threats that it faces from punitive defamation suits brought by powerful people, including the current president. For the moment, New York Times versus Sullivan, which provides that kind of protection against punitive lawsuits, remains good law, and at least by my lights, what we now refer to as the legacy media or the mainstream media does a very good job in reporting the news. You can disagree with their editorial opinions and what their columnists have to say or not, but from the Wall Street Journal on the right to the Times, arguably on the left, they do a good job, I think.
Well, I don't think people understand, and perhaps you can educate us on the protocols that are in place. Let's just take those two examples you gave us. As a criminal defense lawyer and handling cases sometimes that are newsworthy, I know that if I am talking to a press person, I have relationships where if I say something that I don't want to be quoted on, they respect that, and I respect that. But there are some journalists that don't respect that, but that's just an individual choice. But educate us on the protocols involved in the editorial process. I don't think people understand how many layers of, for lack of a better word, check and balance, but I'll get into that in just a minute. But in a typical reporter's universe, he gets information from a source. He wants to write a story. He didn't just write that story and it gets published. There are layers of people that are looking over that person's shoulder before that story gets published. Am I correct about that?
Oh, that is quite true, and in my mind, that's what distinguishes in significant part what I think of as the press from, what in the old days they called the lonely pamphleteer, and now they call the person on the internet with a blog who just purports to report news. There are layers and layers of editors in most major news organizations, both television and print. Or print, we say print, but words, I guess, as opposed to written words, as opposed to spoken words, that are charged with both maximizing the likelihood that the information reported is accurate and making determinations about whether it's in fact newsworthy and whether it is sufficiently newsworthy that it overcomes any potential invasiveness on, the privacy of the people being reported about. There are standards editors and who speak to those kinds of issues and are brought in to deal with significant stories where that's an issue. Major news organizations have fairly sizable law departments where there are lawyers involved in the process to make sure that the editorial process and the editorial product that comes out of it are consistent with governing laws. it's people, as you say, people would be surprised to know how many people go into each story that appears in a major news outlet, be it CNN or the Wall Street Journal or the New York Times. That said, technology has required news organizations to a significant extent to kind of grapple with how to maintain those standards in a digital age. As you know, and I'm sure your listeners know, many reporters now have Twitter accounts or Blue Sky accounts or Instagram accounts or whatever, and are posting to those accounts news and information that they gather during the course of a day, with a rapidity that would have been unknown 25 years ago when, there was an editorial meeting at 4 o'clock every afternoon to decide what would be in the next morning's paper. The news wouldn't come out until the next morning. It's harder to have editorial controls on that kind of dissemination of news. And in that context, you have to rely on the training that you provide to your reporters if you're a news organization, which goes on constantly in terms of seminars by lawyers, explaining to them what their rights and obligations are, to internal seminars about how to deal with things like posting online or updating stories during the course of a day, which happens online now. But it's challenging, and it is a new world out there. But the standards remain the same. It's just grappling with how to make sure they can be honored in a digital age.
I would think that your firm that you're associated with and
no longer associated with. I'm retired. I need to keep pointing that out because I'm not speaking on their behalf.
That historically you were associated with.
Yes.
Are grappling, as you said, with advising those publications that they represent on how to deal with and avoid being caught up in that snare. Surely. I mean, there has to be some lawyer out there who is on top of where the edge is. It's sort of like I had a lawyer friend once said, if you're not living on the edge, you're taking up too much space. And then I had another lawyer friend say, how do you know where the edge is if you don't cross it every now and then? So there's got to be an edge beyond which a lawyer has to advise a reporter that you just don't go. And I suspect that's what your prior firm spends a good time doing, or at least to some degree.
Yes. I mean, I no need to get into the weeds here, but I'll say two things. One is that most major media not most, all major media organizations, as I said earlier, have relatively large in-house law departments, including dedicated lawyers who do nothing but serve the journalists in the newsroom. Smaller publications often do not have law departments or even a lawyer on the payroll, so they have to go to outside firms. So the counseling that a law firm like my former firm or other firms that do this kind of work are involved in are advising smaller publications in the way that you just articulated, and also advising major media entities when everyone knows they're on the edge and
Uh-huh.
they need some advice that the in-house lawyers don't feel comfortable giving on their own. And I'll say one other thing that's important about all of this. When you do what we call pre-publication review or pre-broadcast review or other advice giving prior to publication, you are you have to recognize what the lawyer's role is. I always, when I was practicing, tried to remind myself constantly that I'm not a journalist, and I don't get to make the decisions about what's newsworthy and what's not, and I don't get to say you can or cannot publish this. I always felt, and I think all good lawyers who do what I did continue to feel, is that our jobs are twofold. One is to help journalists get what they want to get into print in a way that doesn't expose them legally, and secondly, to give them a sober and accurate recitation of what their legal risks are and how they might be able to minimize them, but not to say you can't do this. You can say you run a substantial risk you'll be indicted if you do this. You can say there's a substantial risk that if you include this paragraph in the article, you're going to get sued for defamation and I'll have a hard time defending you. But you can't tell them what to do.
No, you can give them advice. Same way in my business. I can give somebody advice, but they don't have to follow it. I'm just a lawyer. That's what I say. I didn't create, or as my brother-in-law, who's now deceased, used to say to me when I would be distraught about a result in a case and I would feel personally responsible, he would say, "You did not give the patient the cancer." That was his way of
great
saying,
line.
yeah, it is. And I say it all the time and attribute it to him. We're just the lawyers, but sometimes we get associated with, for me, the bad guy, even though I'm just doing what the Constitution says this bad guy is entitled to have be done for him by somebody that's somewhere between Clarence Darrow and a potted plant. And you know, the Supreme Court's defined ineffective counsel as something akin to just a hair off of the potted plant. I mean, you don't you don't have to you don't have to be Clarence Darrow and to be effective. It's a real low bar to me that they have put out there, but that's a different issue altogether. Briefly, if I could touch upon what I have said before, is that sometimes I feel we have a blur going on these days. It's been going on for a while. Probably, I use 2016 is the year things changed, or started changing, or started evolving. But the branches of government that were given us by our founding fathers had a purpose in being set up the way it was. And there appears to be a very blurred line between those branches and their respective independence and what was intended to be a check and balance is diminishing to the point where I have felt that what I'm about to say, the press, almost gets to the level of a fourth branch of government uh, because they're doing what our founding fathers wanted to be protected, and that was keep the people informed, both the good and the bad, and the opinionated, for lack of a better word. Can you speak to that issue about the blurring of the branches and how the press might fit into that in its reporting?
Yeah, sure. I think that you're absolutely right. I think that we have been, I think, for some time now in a place where the Supreme Court has become politicized, at least in the public mind. So it is viewed as being aligned with, its supermajority is viewed as being aligned with one political party as opposed to the other. The Congress is viewed as being in the pocket of the president when the president's party controls the Congress. And so you have yourself in a position where they're all rowing in the same direction, and there's no check or balance on from one onto the other, as the framers, I think, intended, and that says, okay, where do our checks and balances come from? And I think it's fair to say that in the last especially in the last decade or so, those checks and balances have come from three places. One is the academy, colleges and universities and scholars writing about issues that and researching issues that ought to be of public concern. The bar, which has an obligation to enforce and uphold the rule of law, and the news media, which has an obligation to report to the public about what its government is doing. It's no accident, I think, that the current administration has decided to go after all three of those in very significant ways.
Yeah.
But speaking to the news media specifically, the one area in which we still, at least for the moment, have operating checks and balances is our system of elections. The only check really now is to, vote the bastards out if you don't like what they're doing.
Right.
And to know what they're doing, you need a free press that is able to provide the citizenry with information that allows them to make informed decisions about what to do with the ballot box. And that, I think was the primary purpose behind the press clause of the First Amendment. Again, it is no accident that the current administration is doing its damnedest to nationalize elections and to make sure that they can manipulate results that they don't like.
And nationalize the media at the same time.
Oh, yes. That is, if I could just speak to that for a second, that is the real concern here, which is at least for the foreseeable future, I am confident that the bulwarks of First Amendment protections for the press will hold. I don't think the Supreme Court will revisit or overrule New York Times versus Sullivan. I think that especially given the clearly retributory nature of the current administration's attacks on the press, that the judiciary will stand in the way of that kind of punitive governmental action. What I am concerned about is a takeover of the media by forces aligned with one political party or point of view that will, as a practical matter, lead to the loss of any real reporting about what that political party and the people he puts in office is doing. And that's what's happened in Hungary. To some extent, that's what's happened in Turkey, and we're certainly appear to be on the early stages of the road to that happening here.
Yeah, we have. What caused me to start a podcast was a company that I was engaged with, Sinclair Broadcast Group, that were doing must runs for their reporters on a message that was being written by somebody somewhere, wherever they were, the same identical message. In Chicago, in Milwaukee, in Birmingham, that's troubling to me. And they call that must runs or something like that. I'm sure you've heard that expression.
Yes.
Well, God bless you for your taking the time to be with me, for getting me up at what is not my normal hour of engagement, although I am generally up. I am not looking to have an intellectual discussion with a bright person. I just want to know where the coffee pot is at this hour. But I got to it, and we got through it, and this has, in fact, been, to me, the real truth. I want to thank you for being with me, and I wish you all the best.
Same to you. Thanks for having me.
Thank you for joining me today on The Real Truth. My name is Tommy Spina. I hope you enjoyed today's conversation. I hope you will follow or subscribe to my podcast and listen in to the next episode. If you found it valuable, please take a moment to rate it and review it. It helps us to reach more listeners that care about the issues that matter. Share it with a friend. Stay engaged, and remember, the truth matters. I'll see you next time.